Hello and welcome to another daily dose of Satoshi's news. Today's day is Monday, the 30th of October 2023, the year of BSV. Buy BSV.live, the best place to buy Bitcoin SV online, the original protocol and genuine Bitcoin. It's a big day tomorrow, my goodness me. So tomorrow marks the release of the white paper on the 31st of October 2008. And we've got this huge court case coming up. So I've literally just had a word with one of my contacts who is literally the best in the business that I know of doing things lawfully and navigating the legal system. So he has just given me permission to broadcast the audio that we've just recorded on what Craig needs to do in order to make sure that his evidence gets seen and heard in court, using Postal Mechanics and filing the evidence so that the judge can't simply ignore it. So I'm literally just going to put a picture up on the screen and play the audio, and you can have a listen. Stay tuned. Right, here we go.
Regarding Craig's up-and-coming case, importantly, there's a document that needs 3 signatures. I think one's the prosecutor, possibly there will be a clerk involved in that, but there will be a document called the preparation before trial. That's really important. That document is basically a document that everyone's been given full disclosure and understands the process, basically everything that goes on in a court case. Now, if this document's not signed by Craig, the court case cannot go ahead. And a lot of the times, people who are going to court, this is something I found that's happened to one of my clients. So basically, the document was meant to be signed, and the guy was not. He didn't appear in court because he didn't confirm the name because the name wasn't his. So what he was saying was, he said, "Well, that name is not mine. It's not correct." He said, "So I'm not willing to attend court." So they said, "Well, if you don't attend court, we're going to just say you're refusing to come to court." And they said, "Well, I can't go to court and say I'm not that name." But importantly, what happened was the prosecutor signed this document, which is preparation before trial. Now, the prosecutor can't sign it. No one can sign that document apart from either his solicitor or him. So that's a really important document that Craig would need to make sure that, one, he's been given full disclosure and he understands everything, and that should come from his solicitor, and his solicitor needs to explain to him about the form called the preparation before trial. It's important because with it being a Crown Court case,
High Court,
this form has to be signed by Craig or his solicitor. Now, normally,
doesn't matter if it's a High Court case, mate. It's High Court, not Crown Court.
Is it High Court? Well, all these cases, because someone's bringing a claim against him, these forms have to be filled out. Even in a magistrate, it's called a preparation before effective trial management in a magistrate court, and in a Crown Court and a High Court, I think it's called a preparation before trial. So the preparation before trial is all the full disclosure, and he needs to understand all the evidence and have full disclosure of everything, and he needs to, most importantly, comprehend everything that's going on. And if that document is not signed by either Craig or his solicitor, then the case can't go ahead. But I assume that his solicitor will sign it, but his solicitor will need to explain to Craig about this form. So that's something that's really important. I thought I'd let you know about that.
Yeah. So is this really important in terms of making sure the judge is in the correct jurisdiction? Because the plaintiffs are literally just simply bringing a case against him. They want him to prove who he is. Basically what they want Craig to move a coin because they know that will pop the largest financial bubble in financial history, and then the blame will land squarely on his shoulders, and people will lose billions of dollars. That's why they want him to that's why they want to force his hand. But really, it's the judge that I'm concerned about, because the judge, as we've experienced in previous cases, can literally just, ignore the rules, or would ignore the rule of law, and just simply provide a ruling that is neither lawful nor even correct. So
what he could do is then invoke Article 6, right to a fair hearing. So whoever brings the claim, if they're making a claim, they've got to prove the claim. So he hasn't got to do anything. So if they're trying to force his hand, he's not going to do anything, because the burden of proof is on the claimant, because they're making the claim. They have to show the evidence against him. He's not going to prove it.
Well, the thing is, Craig wants to show the evidence that he is Satoshi. So it's the judge that I'm worried about, that might try and do something that doesn't allow this. So what's important is that, so moving a coin just simply proves possession. It doesn't prove ownership. And that could just simply, sway the market. Whereas if he can prove, actually, I am Satoshi Nakamoto, therefore I could move a coin if I wanted to, and that's recognized. So he needs to present, he needs to have the opportunity to present this evidence, especially the fact that he purchased the domain name bitcoin.org with his own credit card, personally. That's what he wants to show, and I have a feeling that the judge might try to wing it so that that's not shown, or they ignore it, or something like that. So
the judge can't. The judge is going to be impartial. He cannot take sides or make a judgment on the basis of that. He can't force Craig to do anything. He has to be impartial. That's his job.
Well, yeah, but we know that they're corrupt as hell.
Yes, we know they're corrupt as hell, but, this is going to be down to his solicitor. His solicitor has to take charge of the case and obviously deal with it, because the thing is, if Craig is not going to speak, okay, then he can't. It will be, I imagine it will be, if it's is the claimants coming under their correct name?
The claimant is coming in calling themselves the Crypto Open Patent Alliance.
No, they can't. They can't do that.
Well, that's what they are doing.
Well, we need to find out who the man or woman's making the claim. It's got to be a man or woman making the claim. It can't be a corporation making the claim, because a corporation is a dead entity. So how can, say, for example, Crypto Alliance, which is their name, make a claim? They can't.
Well, it's a group of companies, including Meta, MicroStrategy, ARK Investments. It's a whole conglomerate that are doing it, and there are other cases pending on it. But like I said, really, it's the only reason that Craig wants this is because he wants his evidence to be shown. The whole point of this is to prove that he is Satoshi Nakamoto. That's what he wants. Okay.
Well, there's no issues then, because if he proves he's Satoshi, then isn't that the end of the case? Because how can they then turn around to him and say he isn't? Because they're making a claim, he's bringing the evidence. Then I don't see what the issue is going to be.
Well, I'm worried. Well, I'm not worried, concerned that the judge might not allow that evidence to be shown.
Okay, so what? Okay, right. So what he has to do, he has to submit that evidence then.
Okay.
So what he would need to do, okay, he would need to file the papers with the court, okay, before as evidence, and they need to do it all recorded, so it's on the court, and then he needs confirmation that it's on court record. So you need to notify the court that you want this document on court record. So it's on the record.
Brilliant. Brilliant.
So another way you could probably do it is send the documents in, file them with the court, okay, and take them in, and then get the courts to give you a document when they. It will be like a notice that goes to the court. So what you have to do is take it to. What you could do is actually file the documents with the clerk of the court, and get them to stamp a document to say it's been filed on court record. That would be the better way to do it. Because once it's been filed, it's on court. It has to be in court record then.
Brilliant. That sounds good.
And that way, no one can actually say this document cannot be looked at, whatever, because it's been filed on the CPO. So what I'll do is I'll find the information how to file it, and I'll get you that information. And his solicitor will need to file everything, so then it's on the record.
Brilliant, mate. Brilliant.
So
that's what we need.
And another thing, what he's a lot of times what the courts do is that you send information in, okay, and a good way of dealing with it was on the back of the page of the documents. So you put a bundle together, okay, and then the back of the documents you put a stamp
in the middle.
On there, no, in the middle, on the bottom right hand corner.
Yep.
Okay, and then what happens is you put a thumbprint on it and sign it. But then what happens is when it goes into court, what they normally do is turn it upside down, so they're looking at the back of the paper. And then what you say is, I believe Craig can then say to the court, oh, I believe you already got my documents that I've filed. And they say, well, and if they've got it upside down, just facing upside down, so they can only see the back of the page, because normally the back of the pages are blank anyway. The judge will say, I have all your papers, but I don't see nothing. But because he looks on it and sees the stamp on there with a thumbprint, it means that Craig's the postmaster, which gives Craig jurisdiction. Then the judge has to turn over and deal with it, with the actual evidence.
Yes.
And that is the way to make them realize that the postal
mechanics.
The postal mechanics.
Yeah.
So basically, that process there would give him jurisdiction over them. So they takes away the jurisdiction from the judge.
Brilliant. Yeah, I can do a video on that.
I will get some information on how we can file the documents in court without them, as in him going as a defendant to file the documents. I'll get all the information how to file it and get a document to say it's been filed. So then that way it's on court record then, isn't it?
Yes.
And I think that's the best way to do it.
Brilliant, mate. That's what we need.
Right, leave it with me. I will get this information for tomorrow, and we'll sort out how to do it. But his solicitor has to do as he's told. He can't be pissing around, because obviously Craig's paying him to do this job, and he has to follow what the client wants, because it's part of the SRA code of conduct, and he has to do everything for the interest of his client. He's basically like a trustee. Like a trustee, is like he's having a position of a fiduciary. So fiduciary has to do everything for the best interest of his client. So he has to even put everything on a back burner and deal with Craig, as Craig's the most important man in the courtroom. He can't put anyone before him, but Craig would have to make him listen, are you going to be acting as my fiduciary on this, something like that. But the fiduciary role is very important. But leave it with me. What I'm going to do is I'm going to get some more information how we can file these documents legally in a court of law. And once you can file those documents, once he goes to court and he files these documents, they're on court record. Then there's no one can. Once you do it the correct way, there's no way they can turn around and say we're not dealing with that. They have to deal with it.
Brilliant.
And if you're saying that's what you want to do, then we can do that.
Yeah.
I'll speak to my.
Yeah.
And then we'll see the best way to do it. There will be court papers that you can fill out anyway to do this. So I'll get all the information. If I find out tonight, I will ring you back. All right.
Yeah, mate. Yeah, Postal Mechanics is really important. Do you mind if I put this audio out just so people can listen to it?
You can do, yeah.
Oh, fantastic. Fantastic. Right, I'll put something together now. That's great, mate. Thank you very much.
All right, take care.
Cheers, mate. See you later.
Okay,
all right, bye.
To file the documents. Once they're filed, there'll be no way that it can be ignored.
Fantastic.
So what we need to do is need to, I don't know what your contact is with him, but you need to probably get all the copies of the evidence that he wants to send. Obviously, he keeps all the originals, and then the copies we would have to put it into a bundle and send it to the courts. But also, we would need to give the claimant copies of it as well to make it, because obviously it's disclosure, so you have to disclose the documents to everybody. And my thing is, I think, you know, if they're going to get all the evidence, they may not even go ahead with the court case. That's the thing you need to be careful of. Mind you, if it's going to go to court, the only way they can pull out is if they get the evidence before it goes to court, and they think we're not doing this, or if we get it in court for when, so it gets into the courts, that it's presented on the day, so everybody gets it on the day of the case. So they have to time it right, which would mean that you'd have to get it couriered to them, so we served it on the day of the case, or the courts could get it like a few days before, so they can go over it. But then the claimant could get it on the actual day or day before the case.
Right. Well, they had a case management conference on the 15th of June.
Yeah.
Earlier this year. And let me just bring up some dates for you. On the 13th of November, it says, on or before this date, the experts in digital currency technology must hold discussion for the purpose of, 1, identifying and further narrowing the issues remaining between them, and where it's possible, reaching agreement on those issues. COPA to serve as expert evidence in the field of autism spectrum disorder, because they're saying that's what he's got. 17th of November, COPA to serve its reply experts reports on forensic document analysis. 22nd of November, on or before this date, experts in the autism spectrum, blah, 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 blah. Right, but it's on the 23rd of October, which has already passed. It says, Dr. Wright must provide responses to all other requests in the request for information, which I've ordered to be answered above. So there's things happening before this. What they've disclosed so far, I have no idea.
Okay. Well, you need to find out what the disclosure is, and then obviously, if he's going to put evidence in, the thing is, if he's going to rely on evidence, he can't bring the evidence on the day because it won't be a court record, so they don't have to. They have to take that into account. Your evidence needs to be in court before the case.
And how many days before is the latest that it can be in?
I mean, I'll get all the information tomorrow, but I mean, what is your contact with Craig, and what is going on with his solicitor?
Well, he'll hear this.
Okay. So what I recommend is that I'm going to speak to my other business partner tomorrow, and I think we should come up with a plan of how to get the paperwork in court. But once we get it all done the legal way, there'll be no way that they can be ignored. There's no way it could only be if something was frivolous or it didn't have nothing to do with the case, but all this stuff is to do with the case. It's evidence that he is Satoshi. So if we can get that in there, it will destroy them. But you have to time it right. You don't want to sort of show your card straight away. But it needs to be, these documents need to be served on everyone. So obviously it's nothing where there's going to be a prosecutor. It's going to be the claimant, the judge, and possibly, I don't know if there's going to be a clerk in the court. I can't see there being a clerk anyway. There may be the judge would have a clerk. Actually, it's called a clerk to the judge.
Right.
So that information could be given to them even like within 24 hours before the case. But let me check it anyway to see how long you'd have to give that information in. But if he needs to prove who he is, that would be the way to do it. But you can't bring that information in on the day and say, oh, well, this is evidence, because it needs to be filed and lodged with the courts. Otherwise, they can say, well, no, you haven't followed the process. We're not accepting that document now.
Got you.
Do you know what I mean? So it's important that you follow the rules, CPR rules.
Yeah. Brilliant, mate.
It's civil matter is, so there'll be civil procedure rules anyway. But I'll get all that information tomorrow anyway for you, and you can just pass it on.
Fantastic. Thanks very much.
All right, mate.
It's been great.
All right, take care.
All right, cheers,
okay,
mate. See you later. Bye.
Bye-bye. So, we would have to send the evidence in 7 days before the case.
Yep.
Okay. We can't just send copies. We need to either send originals or certified copies. So what we could do is, to make the documents look really good, we could get them notarized and get the notary to do copies of it. And it comes with a seal and everything, and it looks all really good, mate, honestly. Have you got any expert witnesses that he could actually bring?
I'm sure he will have, yeah. I mean, he'll have lots.
Okay, so that would need to be put in as well for expert witnesses. That'd be important. Okay, there's certain documents going to be filed as well. Expert evidence, it would have to do, could seek permission from the court to rely on expert evidence by filing an application. So anything that he's going to do, he can't just do it at the last minute. This needs to be done before. So if he's going to bring expert witnesses, there's forms he's going to fill out and notify the court he will be doing this. That'll be part of the probably discovery and disclosure. I know what forms they are he needs anyway. What's the other bit of information they've got? And we need to put it all into a proper court bundle. All the evidence we're going to rely on for the trial, including witness statement, experts, and documents, and all this is to be filed within 7 days before the case in the court bundle.
Brilliant.
So I think just from all the stuff I've got, I've been looking through all the stuff what we need for stuff like this. So I reckon definitely we can get the paperwork in for the court. The court can't ignore it, man. Once we follow the civil procedure rules, there's no way the court can ignore the evidence then, because it will be on the record. It'll be on the record. So basically everything he would have to do would be, obviously he needs to keep all the originals, but he would have to get them, I would say, I don't think you need to get them notarized in this country, but you could get them all certified anyway by a solicitor, which he would have. So the solicitor would make copies and make sure he has a stamp to say they're certified true copies. So that can either be done by a notary, which I've got a contact for that, or I'm pretty sure he's going to have contacts with notaries. But notaries are only for when you're using documents abroad. I mean, you could use a solicitor to get them certified as true copies. So they would all need to be, and then we'd have to fill out. There's quite a few forms that you'd have to fill out, we'd have to get in as well. And the good way to see if his solicitor is on his side, he should be talking about all this stuff I'm telling him. Like, he would need an N285 witness statement, N263 expert report form. So if he bring an expert in, this form would need to be filled out, and then there's a normal form, which is M244 for application of notice. N32, order for examination and witness statement before trial or hearing. And an N33 for an order for the issue of a letter of request for judicial authorities out of the jurisdiction. So that's going on about jurisdiction and stuff like that, which we don't think we didn't need that one. And this other one, and then there's going to be sort of a witness statement that has to go on an N35. There's quite a few things on here actually now, which seems to be quite really interesting. But it's quite interesting, mate. So I think by tomorrow I'll come up with a process, and this way we'll know if his solicitor is going to be playing ball to see what he's going to be doing. Because a lot of these things I'm telling you on here, these are all part of what his solicitor should be doing anyway. So I'd be interested to see what his solicitor's done so far for him.
Right, mate. Sounds brilliant so far. Sounds brilliant.
Yeah, I mean, if that's what we want to do, if you want to get the paper on court record, that's what we need to do, and he needs to know this as well.
Yeah.
So he needs to instruct his solicitor to make sure it's done, basically.
Right. Okay. Well, what I'll do is I'll put this out, and then I'll put our chat out tomorrow as well, and hopefully either him or his associates will get back to us.
Okay, man, no problem. I'll see you later.
Cheers, mate. See you later. All right.
Okay, bye-bye.
Bye.